We are here in the matter of the people of the state of Michigan versus Shamika McCallie, case numbers 20-02124-FH and 25-02388-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Mr. Beeson's request to withdraw his counsel in this matter. That is also supported by a certified or a notarized letter I received from Miss McCallie requesting new counsel due to a breakdown in the relationship. I would invite counsel, will you please place your appearances on the record at this time?
Tiffany Burks on behalf of the people.
And Mr. Beeson, you're muted.
Sorry. John Beeson, Your Honor.
Thank you, Mr. Beeson. Anything to add to the motion, Mr. Beeson?
No, Your Honor. Ms. McCauley is present, but she has her audio on.
Yes, no, that's fine. Any position from the people on the motion to withdraw his counsel?
No, Your Honor.
All right. Well, in that case, I will grant the motion to withdraw because Ms. McCallie has indicated a breakdown in the relationship. And Ms. McCallie, is it your intention at this point to request appointed counsel, or are you going to hire new counsel on your own?
This is a motion for me to get off probation, right?
I think there also is a motion to terminate probation in here. You know what? Let me handle the counsel one first so we can determine whether you're supposed to speak on your own behalf for probation. I had two motions, Mr. Beeson's motion to withdraw, and then also, yes, you're correct. Your next one up is yours to get from probation. So, what's your intention going forward with regard to an attorney?
I do not wish to have Mr. Beeson represent me, Your Honor. I made it clear to Mr. Beeson that I did not wish to sign a waiver, and he manipulated me into signing the waiver, did not give me a copy, and I had to obtain a copy of that waiver, which is why my case was bonded over. It has also been on my record that I have absconded for 2 years, and I've never ran. This is a major problem. It has stopped me from being able to better myself, Your Honor. I am very frustrated. I don't owe you guys anything. I don't owe you guys any community service, any money, and I am still being punished.
Sometimes people forget that freedom itself comes with a price, and probation is not a punishment. It is a second chance that most people would beg for while sitting behind a cold jail cell thinking about what they lost. It is a trade between trust and control, between faith and rules. When the judge gives you that chance, it is not mercy, it is a test of discipline, of humility, and of change, and yet so many fail it because they think they beat the system, when in reality, they just delayed. The consequence, every choice you make in that free world becomes a mirror of who you really are, and the way you treat that freedom shows how much you value it. This is not about punishment. It is about responsibility and self-reflection. You can blame the court, the world, or your father. But at the end of the day, it all comes back to one thing. Choice, and what you do with it defines your story forever.
All right.
May I address that real quickly? Just so
you may, Mr. Beeson.
The record is, I have nothing to do with her previous, whether or not she has a notice on her file about fleeing. That was my concern. Secondly, Judge found over Ms. Cawley from the prelim. She signed a circuit court waiver. Her case is already bound over. And I explained to her that by signing the document, she did not have to attend in person for the plea not guilty from the circuit court judge. So I don't know if she understood that or not, but you can clearly see there's a breakdown. So I ask the court to grant my motion.
Yep, no, I can see the breakdown in the relationship. I will grant the motion and allow your withdrawal at this time, Mr. Beeson. And I'll ask you, Ms. McCallie, is it your intention to hire a new attorney, or would you like me to appoint an attorney or have the defender's office assign an attorney to represent you at this time at no charge?
No, I would like to get this motion going. I don't need an attorney. I'm not, I'm
Yeah, I'll
just
continue
speaking
with your
to.
motion today. I'm just thinking, going forward. And is this the only thing you're in front of me on, or is there, because my review of the case indicates there might be another case coming here.
Driving while intoxicated was bonded over in front of you. Also,
Okay,
the
who's
reckless
representing you on that
driving,
one, Miss McKaylee?
I am, I am currently, looking for someone to represent me. I have a lot of support. I am in the FIT program and we are looking for an attorney to represent me in this situation. Also to take care of that, absconding that was on my record. That has really put me in a bad situation.
Okay, all right. Well, what I have here is I extended, let's see, probation here for 90 days. Because of that OWI that was pending in 61st and has now been bound over and will be in front of me in May. And I amended the discharge date from probation to August 23rd of this year, based on that. And, based on the additional charge for OWI, I don't see any alternative here but to keep you on probation for that time. Are you still wearing the scram, Miss McKaylee?
I am, Your Honor, and I have been wearing it since November. I have no problem with wearing the scram. I am in cosmetology school because I tried to take CNA and I was denied because I was listed as absconded too for 2 years, which
Yeah,
makes
no,
my
I
guidelines
yeah.
go up, which is a major problem and it's not being acknowledged. So I need
You,
an attorney behind all of this stuff that's going on. The amended sentence was not represented to me. When it was represented to me, it was represented to me first without a signature by you. It's just been, I haven't got anything in the mail. Um, it's
do
been a
we do
lot.
we have
I
a
have,
good mailing address for you, Miss McKaylee?
yes, you guys have a good mailing address for me.
Could what is your current address that we should send stuff to? Okay, yep, that is what we show in the court record here. So that is good. We're at least sending stuff to the right location. What I will do, well, in the meantime, prior to that conference, and Mr. Beeson has represented you on that case up until this point. Now you don't have an attorney. What I will do is direct you to obtain an attorney within the next 2 weeks. Yeah, so that's, gosh, 2 weeks is just going to put you a week before that. If you don't have an attorney prior to that date, what I will do is I will appoint, a court-appointed attorney to represent you, so you have representation at that hearing. So today's order, though I'm going to keep you on probation, it will direct you to obtain counsel on the new case of your choice, or I'll appoint counsel.
Your Honor, this case has been pushed out and it is hindering me. You guys extended my probation past my max date.
The truth is, arrogance is a dangerous disease inside a courtroom. You might think you know it all until the law reminds you that you do not. The people sitting in front of you have spent decades studying rules you barely understand. They have lived through cases that would break your spirit in a single day, and yet you think you can outsmart them with overconfidence. It is not just ignorance, it is delusion. The best thing anyone can do when facing the system is listen, learn, and adapt. Not argue and collapse, because every word you speak carries weight and every mistake can turn freedom into years behind bars. Wisdom is not about talking louder, it is about knowing when to stay silent and when to act smarter. Because, at the end of the day, law always wins against ego.
No,
You did not
I did,
extend
but
it for
given the
30, for 90, for 60 days. You did it for 6 months.
yep, well,
Um,
and given the circumstances, when I have because I do have you on probation, for OWI, and if that ever happens and I get someone else that picks up another OWI charge, I keep them. I'm not treating you differently than I treat anyone else. I do keep folks on probation, and it's mainly because I want to be able to monitor whether you're drinking and driving during the probationary period. If you were, then I would take the additional step of holding you in jail. You're not indicating any of those problems, and the scram, as far as I know, has been good for you. So I mean that you've been compliant with the scram conditions, which is a good thing. That gives me the assurance that the public's safe while you're out there while we get the new case worked out. So that's all information I can give you.
Judge Rossi, you also told me that you were going to release me from probation back in September, and that did not happen. Like, I am getting the runaround with you guys, and I do not feel like this has been fair. I am not disrespectful, so I'm not going to question your authority during court. If you tell me something that you're going to do, that's what I expect. That was supposed to be done before this event even occurred. The reckless driving was thrown out, so I don't even know why you guys would be coming at me for a DUI.
Okay, yeah, well, the indicator I have here is that it's a reckless and an OWI in the 61st District Court. Is that what or did you just get bound over on the reckless?
Sometimes a single choice can cost you everything, and the worst part is it often comes disguised as fun. One drink, one shortcut, one mistake, and suddenly your life is in the hands of a judge. Not your own when you have a job, a family, and a future on the line. That drink is not worth it. It is a gamble with your reputation, with your income, with your freedom. You can convince yourself that you are in control until the flashing lights prove otherwise. If you know that wearing a scram device could cost you your job, then maybe the real question is why you needed it in the first place. Responsibility does not start when you are caught. It starts when you make the decision not to cross that line. Every action echoes louder in a courtroom than it ever did in a bar.
I didn't get bonded. The reckless was dismissed.
I
With
see. But I still
prejudice.
have the OWI coming in front.
Right.
Yeah, no, and that's the more serious thing, and that's what's going to require, to be addressed by your lawyer.
Your Honor, I wasn't driving, so this is just hindering my life.
No, I get it. And I understand that pending charges and the absconding charge and all of those things have a serious impact on your life. And my flip side of it is, I do apologize. I know it can feel like the system kind of pushes and, moves you around without much regard to what's really happening out there. However, I can tell you, from my perspective, particularly with OWI cases, I am in favor of resolving them. However, I've got to look at the, unique situation of the concern about public safety when I've got someone with OWI charges, because, as if you got behind the wheel drinking or having used something, as I describe it, it's like shooting a gun into a crowd. It could, you might not hurt anyone, but then again, you might kill someone, and it's just too much of a chance for me as a judge to take. So I've got to be extra cautious with OWI charges, and I always am. Just for the public safety aspect. So that's the best explanation I can give you at the moment. However, once we get an attorney and we get that status conference, we can address those things in front of me. I can advise you, if you plead guilty on another OWI charge, the likelihood is that you'll remain on probation for an additional 3 years. That's my policy, at least on every OWI third charge that comes in front of me. So just so you're, got some parameters to think about going forward. And like I say, if you're successful hiring a new attorney, have that attorney file an appearance. If I don't see an appearance by a week before that status conference, I'll send it over to the county and have an attorney appointed.
If I'm not able to get counsel, I don't wish for nobody from the courts to represent me, Your Honor. I have no faith in you guys.
Awareness is a gift, but not everyone has it. And watching her speak, you can almost feel the distance between what she believes and what is true. It takes a special kind of denial to argue against evidence that screams louder. than your words. If the device keeps you clean, then it is not the problem. You are the problem. Logic is simple. If you only stay sober when watched, then maybe you were never really trying to change in the first place, and yet people convince themselves that rules are unfair when the rules are the only reason they are still standing here today. Every judge sees through this pattern, every excuse, every cycle of blame and regret. Self-awareness could have saved her, but instead, pride buried her deeper.
No, well, and all I can
reason.
tell you is those offices are independent, the defender's office and our court-appointed counsel list. Other than the fact that we're all, well, I'm paid by the state of Michigan, but my staff and the rest of the court's paid for by the county, and the defender system is also paid by the state of Michigan and the county. However, we don't have any control. They should be an independent advocate for you. In other words, they don't work for me. They're there to represent you in the system. So, and I can tell you, you'll be much better off going forward with an attorney than going forward on your own, because the attorneys do.
You guys don't have me driving. This case is pointless. It's just holding up my life. That's all it's doing.
Yeah, no, and that is very much the effect of this type of
And you guys
charge.
extended my
They
probation
do.
past my max date, and I
They
don't
do.
owe you guys anything. I've done all my community service.
No, the number one concern here is the new charge. At this point, Ms. McKillian, we'll deal with that when I see you in May.
So the reckless driving, if they dismiss that, I don't understand why they're still pushing for the DUI.
Yep, that's a question for the prosecutor and for your attorney to discuss, either prior to that conference or at that conference. So, like I say, if you're successful hiring an attorney, have them file an appearance, and they can get talking to the prosecutor's office. If not, I'll get someone appointed. The faster that happens, obviously, whether you hire an attorney or I appoint an attorney, the more communication they can have in advance of that conference to address your concerns.
So, okay, can you tell me about why you told me you were going to let me off probation and did not do it?
Well, I can't tell you exactly because I unfortunately don't remember every single thing I say when I'm
But it
in
should be
court.
on record, Your Honor. It should be on record. We did
Yeah,
that in
no, and
court.
I do
I
have
lost
the
my
one.
job behind being on scram again, like I told you it was going to happen.
The real issue is not bad luck, it is bad behavior. And until she sees that no amount of second chances will matter, you can tell when someone is trapped in their own narrative. They twist the truth until it fits their comfort, and then act shocked when the world does not agree. It is a psychological cage built from excuses and half-truths. When the judge calls it out, she acts offended, but deep down she knows it is true. Growth starts when the lies stop, when you stop defending what broke you and start fixing what made you fall. Maybe she believes the system hates her, but what she is really fighting is accountability, and that battle no one can win but herself.
And I lost my job, and I was like, okay, that's fine. I got some health issues going on, and I'm going to be off probation, so I can just sit down and go to school. I could not do that because of the absconding.
Yeah, well, and I know
Then,
why I
when
put you on the scram was because the
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 violation,
violation, right? That I can tell you, but I can't say, yeah, and I can't
but you
say
didn't
that
take me off
obviously.
probation like you told me you would. You said if you do scram with no hiccups, I'm going to take you off. That did not happen.
And I had you on scram starting on March 8th, and you've been on now for what are we at here?
March
We're not.
8th. No. Your Honor, you put me
Oh,
on
that's March
scram.
8th. Oh, I see. Yeah, when did we put the scram on? You said
I've been on
November.
scram this time since November. Before I got off scram in September and I was supposed to be let off of probation. That was what you told me in court. I told you I work at a medical factory and that I believe I will be let go because of this scram because it's a very conservative place. I was let go. When
Yep.
it came
No.
time for me to get off of scram off scram, I was told by Shannon that I'm not eligible to be let off of probation, which I don't understand why you would even tell me that.
Yep.
That
No,
feels as though it was to mislead me so I would accept the scram. I did I've been on scram 4 or 5 times. I've never dropped dirty on Scram.
Back in 2021, she was handed a roadmap out of chaos. Probation was her escape ticket, a deal that said prove yourself and walk free by 2024. But like so many others, she mistook mercy for weakness. The judge even opened a door to early freedom. All she had to do was finish 4 months of clean Scram monitoring, and to her credit, she did it. She tasted hope. She saw the finish line. She thought redemption was finally hers. But second chances are fragile. One careless step, one old habit, one reckless night, and everything comes crashing down, because the system does not forget. It only waits for you to prove who you truly are.
Yeah, no,
Never. I am
that's-
not being acknowledged for none of this time or none of this work that I'm putting in. My life is only being held up.
Yeah, and I see what you're saying here, because
I
you
put
started
myself
that
in treatment.
probation, looks like on February 23rd, 22. Well, and the other explanation as to why I would have
22.
not let you off. Yeah, well, that's when this case started, right? When I put you on probation in the first place. Would have been February
This case is
22.
from 2020. Actually, 2019 is when the case was.
Yeah, though we probably entered the order, the plea resolving the case could have been 2022.
Okay, so what do I do about, I don't want to be disrespectful, but like, what do I do about you telling me one thing and that not happening?
Well, the only safe way, as I tell people in anything, is to have me reduce it to an order. There are two ways that can happen. I can do it on the record in court, and your attorney can obtain transcripts of what I say in court, and I do honor that. If I say it on the record in court, then I do follow what I said. And then second is, I do a written order. Sometimes your attorney will generate a written order for me to sign, and then we have it in the record. So then when I make a representation like that, and that again assumes nothing changed. And I look here and I say, well, what changed? And of course, the biggest change was you picked up that additional OWI.
That was 2 months after I was supposed to be already off.
Yeah, and I'm looking
And
at
it's not, I
this.
wasn't even driving. So it's just me being at a scene. You got my name coming up, and now because
Yep.
I have a history of DUI is really why I feel like you guys are coming after me. But that's personal feelings. And
Yeah,
I'm
well,
not
and I
gonna.
don't make the charge decision, that's entirely the prosecutor's office, and then it gets in front of me, and they'll give you an evaluation based on the facts of the case. It doesn't, just because you're charged with it does not mean, of course, that you'll ultimately be convicted of it. But, well, it is a pending charge, and because of the prior OWI, I need to be cautious and extend the probationary.
But why didn't you follow your order of taking me off probation?
Well, I think the number one reason that I can give you on that was picking up that.
I didn't have a case when it
I
came
see.
time for
Right.
me
Well,
to get off
and
probation.
your probation would have ended with the scram, is what you're saying. Well, and it's
In September.
right about the same time, because I put you on scram
No.
November. You'd have been on there for at least a couple of months till January.
Well, I'm talking about September of 2024. I was supposed to be off of probation, off of scram, done. That was the agreement you told me in court. You said, I feel like it's necessary for you to do scram. I told you then I have done scram. I think then it was like 3 times. And I've never had no issue with scram. You said, well, you do scram this time and you have no hiccups. I am going to let you off probation. That did not happen. That was the first week of September when I questioned William Shannick about it because I was transferred back to him from Dominic Milton. He said, I remember the judge saying that in court, and he told me he was going to look into it. And then he said, oh, you're not eligible to be let off of probation early. So that's where my frustration come in at.
Yeah,
And
I
then
would
this case
understand it.
being
And
totally BS, and it's like really holding on my life and stopping me from being able to better myself.
When the judge promised her early release, it felt like victory. But reality hit hard when probation said no. The disappointment was written all over her face. She thought it was betrayal, but it was bureaucracy. It happens all the time. The judge's hands are tied by the law. They can want to help you, but the law decides, not their heart. This moment right here shows the hardest truth about justice. Sometimes the system can forgive, but it cannot bend the rules just to make you happy. She learned that lesson the hard way, and instead of accepting it, she turned bitter, blaming everyone but herself. And that is how second chances turn into lost ones.
No, I get it, and all those are valid considerations. However, the only thing I can posit there is that what got in the middle of this is we were coming close to the time when you would have been eligible because of the expiration of the 3 years of I put everyone that's an OWI third on 3 years of probation. Sometimes I let people off 90 days early from probation when they have a good record, and that's what would have happened had you.
It didn't happen, is what I'm telling you. It didn't happen. This case is 2 months after I was supposed to be off of probation. You did not let me off.
Yeah, no, and the only thing I can tell you is what happened there is you picked up that.
Your Honor, I picked it up 2 months after you told me you were supposed to let me off probation.
Well, that was contingent on nothing else happening, and when you
I
pick
was
up a new
supposed to be
charge,
off, Your Honor. You keep saying it's because of this new case.
yeah,
I was supposed to
no,
be off September. This case was caught at the end of October.
yeah,
And
I
like I
get
said,
it.
I wasn't driving. I went and hired an attorney. He did not do what I told him to do.
Well, and I don't have
I'm
any
really
facts
feeling like
about
I
that
need to
new
get
case.
other people involved because this is ridiculous. You guys have
Well,
had me as absconded for 2 years. 2 years. I've been to jail. I've been in front of you. How is it possible?
yep, and I
I
have
am pissed. I'm not even gonna lie because I am trying to be better. I am trying to better myself to be a good example for my children, to make my life more financially stable, and you guys are hindering me.
well, and that I can certainly see how you'd have the feeling. However, I got to deal with the new charge that's in front of me, and that's what's gonna, kind of set the course
Well, I
for the
have to
next
go in
3
front of you.
years.
I don't see why you're keeping me, why you're denying my motion to be off probation. I
Yep,
have to go in
no,
front of you. You guys dismissed the reckless driving, so I don't know how you're going to give me with a driving period because I wasn't driving. I was
well,
with
you're
a
gonna have
licensed
to.
driver, wasn't in the car or nothing.
I can't weigh in on that because I don't know any of the facts of the new case, but you're gonna have to address that with your new attorney.
Okay,
Good luck to you, Miss McKaylee.
sure.
And just like that, the hearing ends, but her story is not over, not even close. There is another case waiting, another day, another excuse, another cycle. She will stand before the court again and try to convince the world that she is the victim, while the truth sits silent in the evidence file. What she refuses to see is that healing starts where blaming ends. The judge can guide her but cannot save her. The audience can watch but cannot change her. She holds the pen to her own story and yet keeps scribbling the same chapter. If she ever wants peace, she must first stop fighting reality. Until then, she will keep losing in the same courtroom again and again.